Hello, I'm Patrick Farnsworth. Welcome to Access and Privacy Online Commentary. We continue to see developments in Alberta and fallout from these substantive changes to the province's Freedom of Information and Protection of Personal Information Acts. And so joining me to discuss these changes are some voices frequent listeners may be familiar with. Let's dive in. We are joined by FIPA President Mike Larsen. Mike, good to see you again.
Always good to be here.
And we have Executive Director Jason Woywada. Hello, Jason. Good to see you.
Hello, hello.
And we have FIPA advisor and Fasken lawyer Samantha Delechantos returning to the podcast. Hello, Samantha.
Hi.
All right. So, just really thankful to all of you for making the time this morning to do this. And so, we're going to start with Jason. Jason, you wanted to give us a bit of a rundown, a lay of the land, as it were, and give us a bit of a rough chronology of some of these really significant changes, as subtle and nuanced as they may be, but significant changes that we're seeing here. So give us a bit of a rough chronology of what's going on.
Yeah, and the important thing to remember here is this didn't just happen overnight. This started in August of 2023, where the Information and Privacy Commissioner of Alberta launched an investigation into the government of Alberta's processing of and response to access to information requests. Flash forward to November of 2024, they introduced changes to Alberta's FIPA, splitting it with Bill 33, the Protection of Privacy Act, and Bill 34, the Access to Information Act. On December 5th, those received royal assent and were set to come into force this spring of 2025. We were really pleased to be able to hold an Information Summit event with Commissioner Diane McLeod reviewing the changes in January. March of 2025 saw public consultations on the regulations for these acts, which resulted in some minor amendments prior to their proclamation. And that brings us into the last few weeks. May 9th, we see the investigation results from that 2023 investigation, with the Information and Privacy Commissioner finding the government of Alberta non-compliant in processing access to information requests under the FIPA Act. And then May 14th, we see this Court of King's Bench Justice Colin Feasby ruling parts of Alberta's FIPA don't meet constitutional checks. So there's a lot going on here, and that's why we thought it was good to get everybody in the room to sort of go over these things and break that down a little bit.
Yeah, I think we wanted to have Mike kind of go into some of the background of that ruling, and then we'll also have Samantha come in as well. But if Mike, you wanted to take it away.
Yeah, absolutely. So this is a topic that's going to be familiar to anyone who's been following privacy and surveillance in Canada for the last several years. So this stems out of a joint investigation done by a number of provincial commissioners, including the Alberta Commissioner and the federal Privacy Commissioner, around the activities of a company based in the United States called Clearview AI. Clearview AI is one of many companies that provides surveillance services that use a algorithmic artificial intelligence kind of base. In this case, they do facial recognition technology services, which they sell on a subscription basis to primarily police organizations in the United States and in Canada. And they develop their databases, which they're very happy to promote as being, billions and billions of images, based on automated scraping of online content, and specifically content that's posted by people to social media. So it's out there, it's scraped, it's processed, and then made into a searchable database, primarily, again, for policing uses. This was used on a pilot basis in Canada. And when it came before the commissioners, there was a significant investigation that took place. And that investigation found, first off, this is focusing specifically on the actual activities of Clearview AI. Found that they were not in compliance with Canadian privacy laws. And in this case in particular, with the Alberta's Personal Information Protection Act, which is similar to BC's Personal Information Protection Act and kind of analogous to the federal PIPEDA. It was found non-compliant for a variety of reasons, but it had to do with whether there was consent to the collection, use, and disclosure of personal information through the scraping process, which is required under PIPA, whether the process itself was reasonable, and basically whether this company was appropriately following the law. The findings were robust and really detailed, and the commissioner said, no, they're not following the law. They're not compliant with these requirements under PIPA, and then they ordered Clearview AI to desist. By that time, they'd already stopped providing services to Alberta Police, but they had previously provided to Edmonton, to Calgary, and to RCMP. So this was something that was in use at the time that these kind of processes kicked off. So here we are now, and I'm going to turn it to Samantha in a second, but we're having this conversation today because Clearview AI challenged the order on a number of grounds, right? They challenged in terms of whether the Alberta commissioner even had jurisdiction over an American company under Alberta's FIPA. They challenged whether the specific provisions that apply under PIPA for the collection of publicly available information were appropriate, were they constitutional, and they also challenged on whether there was restrictions on their freedom of expression as protected under the Charter of Rights and Freedoms. So there's a lot of stuff going on in this decision. It's a complicated one, but we can break it down. I think there's some interesting findings and some interesting, I would say, hints about issues that are going to come before the courts. I think increasingly in the future as we go forward. So maybe we can turn to Samantha to talk a bit about the jurisdiction question here. How did this come up and what did the court find?
Yeah, so I think the jurisdictional question is something that's being talked about across the country right now. Stemming from the joint report for Clearview, the BC Commissioner had also made a similar order to the one that was made in Alberta, and that was also challenged and heard back in 2024. So in December 2024, the BC courts had reviewed the same or similar decision, and in that case, they had also decided at the time that, well, jurisdiction is accepted. You know, BC commissioners do have jurisdiction because you have a real and substantial connection to BC. Now, they did consider those factors around, well, you know, you're a US company, okay, maybe your data is stored overseas, maybe all your operations are overseas, but, you know, what were you offering in Canada? What were you offering in BC? And now what were you offering in Alberta? And when the court in both BC and Alberta turned to this issue, they looked at that trial of, you know, with RCMP, with the police, local police services, and they said, well, no, at that time, as you said, Mike, they were engaged in active trials with these new customers in Canada, both BC and Alberta. And as such, you intended to operate and offer your services here. Yes, you chose to temporarily suspend when we started this investigation. So they weren't providing services, but they were at some point. And they always said it was a temporary suspension, that they would come back later on once the investigation was done. So they expressed this intent to start operating and providing their services back in Canada and these particular provinces once again. So, you know, the courts in both provinces determined, well, no, you have a real and substantial connection because you're offering your services here. It's not just a pipe dream. It's happening. It has happened, and you intend it to happen again. And you can't just operate here and offer your services without being subject to oversight and the laws that protect individuals here. And so, you know, the Alberta Commissioner courts, I should say, they did look at that BC decision as well, and they did uphold the same reasoning, is that they do have jurisdiction here because of that connection to the province.
That's a great overview. And I thought it was interesting in the decision that there was also this emphasis that this question of jurisdiction in these kinds of cases needed to be interpreted in ways that should facilitate, not frustrate, regulation in the public interest. In other words, if we have a question that hasn't been answered yet and we're trying to decide if jurisdiction applies, let's look at the actual public interest of legislation itself, which in this case, in addition to those reasons, really mitigates in favor of reading jurisdiction into this. And the court specifically says, you know, it would probably be inappropriate for there to be an order from Alberta's commish on what Clearview AI can do in a different country or in a U.S. state, of course. But we're talking specifically about Alberta here, and all those things do apply. So, okay, that's one argument sorted out, and that's kind of the foundational one. Can we even have a ruling in this case or a decision from the commissioner that matters? And then we turn to this question of, I think, the more specifics of what's going on here, which has to do with the sections of PIPA that deal. This is the private sector focused Personal Information Protection Act in Alberta that deal with when information can be collected, used, and disclosed. And the court, you know, refers to this kind of belt and suspenders approach a couple of times, which is to say that there are kind of these two overlapping rules in PIPA. So one is kind of the source-based rule, right, where there's an exception that's allowed for the collection of personal information, which normally requires consent. Has to be consensual unless it's publicly available information that's based on a list of sources provided by the FIPA regulations, what constitutes publicly available. And then there's also a prohibition on collection with the exception of purposes that are reasonable. And so both of these things are kind of coming into play here. Of course, Clearview AI did not obtain the consent from the billions of people whose images it scraped from the internet. So that and it would be completely unfeasible in terms of their model, their business model, for them to do so. So does this section apply? Is the question. Is the interpretation of the commissioner, which is that there was no public available exception to this, that they actually allowed Clearview AI to collect this information, was that reasonable in this case? And what did the court have to say about that?
Yeah, and so there's sort of two aspects of it, and this kind of went into that constitutional issue because when the court was considering the actual definition of publicly available, the definition really focuses on magazines and electronic publications and newspapers, for example. It really doesn't contemplate in the definition the publication of anything on the internet, like especially with regards to social media account where individuals can post their own content whenever they want. They're not really their own publication as per the act. And so, Clearview really took to this and said, well, if you're going to say that publications are so narrowly defined to just these things being magazines, newspapers, or electronic publications that are similar, and you're not looking at all of the content that's posted on the internet, on these social media platforms, then you're essentially saying that any information that's not published in one of these forms is subject to that consent requirement. It's not excluded from the consent requirement as such. Even the Googles of the world that go scrape and index websites and content, that would be subject to this consent requirement, and that's a little bit unreasonable. Now, when the court considered whether the commissioner had interpreted that definition reasonably, they had agreed and said that the commissioner did interpret the act and the regulations and that definition of publicly available reasonably, and that it was a reasonable interpretation. However, when they then turned to the consideration of whether this interpretation causes a charter issue and imposes restrictions and obligations on this freedom of expression under Section 2B of the Charter, that's where the court said, well, yes, we do think it infringes on charter rights, freedom of expression. And they went through all these considerations around, firstly, is Clearview engaging in activities? Is there scraping? Is there bot scraping the internet? Is that an engagement in freedom of expression? And the court had determined that, well, the act of scraping itself is not engaging in freedom of expression.
Thank goodness.
But when they're expressing that to their customers for a particular use, in this case, they always do, for their customers to carry out their duties, etc., that then comes into that definition and has charter protections, them applying it to customers. So that was interesting. And then when they consider the analogies to these other companies, and Google was heavily discussed, again, because it is such a mainstream tool that is used by billions of people across the world and is a necessary tool, a lot of people would argue, in our current society to easily index and find information, images, etc. on the internet. And as we all know, Google is not restricted in what it is indexing, although Google does allow you to, the commissioner raised this, that Google does allow you to remove indexing, to request to remove indexing if you want. So that's slightly different to Clearview. But it still is very similar actions, right? They're scraping, they're indexing, they're not getting consent. And when the court turned to this particular example, they decided that, well, no, it's really, we can't say that actions of Google, for example, in this scraping would be unreasonable or not of publicly available information, because if we do that, it's not really practical for Google to get consent. And as such, it would put a spanner into the works of this useful tool that's got more public good than it is issues with it, essentially. And so using that consideration, that broader purpose and broader impacts of this particular definition on the internet and the tools we use, they decided in that context that publicly available was not constitutional. It was infringing on the freedom of expression of the internet. And so the court had decided to grant Clearview AI's request to say that these particular sections in FIPA and the regulations were unconstitutional. But the thing is that the court's remedy in response was not to strike down these portions of the act just wholesale. Instead, they said, well, we're going to just change the definition of publicly available in the regulations so that it's not limited to including, but not limited to magazines, newspapers, and electronic publications. So there's not this narrow interpretation of what a publicly available text or image is. So that again, if you have a reasonable purpose and you otherwise fulfill the requirements of the act, you can go scrape and use publicly accessible data without consent, because the definition of publicly available is now broader to encompass the internet.
And really, really interesting aspect. I think it's probably one of the most interesting aspects of the decision here, and also to hear the arguments made by the different parties in this case. So, the commissioner, the judge in this case, Judge Thiesby, did not kind of simply side with one side or the other, and instead took little bits of arguments from both. Clearview AI was making an argument that was incredibly expansive in terms of their authority to collect whatever they wanted, and they had this kind of notion that de facto, by putting anything online and clicking on any consent terms, that anything was available. There was no reasonable expectation of privacy, and the court very much disagreed with that, and instead kind of focused on this issue of freedom of expression and FIPA's limits on that. There was a quote there. It's at paragraph 147, where the judge says the FIPA regulation is notable for how it fails to grapple with the challenges to privacy posed by the internet with any sensitivity to how the internet works, which I thought was a pretty interesting dig. Essentially, I guess if they were to find in favor of the commissioner here, then by extension, that would also be a finding against the basic functionality of Google, was the argument they're making. And so,
for this particular
and
one,
since
yes.
the commissioner hasn't gone after Google, and actually recognizes that, and the court recognizes that Google is perhaps the primary way in which people find information, then there has to be, consistency on that front, which I think was really interesting there. So the overall effect of this, then, I guess if we kind of try and bring it home, there's lots of, I think, pieces of this that'll be picked up and explored in future. I mean, decisions around what constitutes expression vis-a-vis scraping. There aren't too many Canadian court cases that really get into, does expression require humans? Or can expression be done exclusively by algorithms? When does an algorithmic kind of bot scraping become a form of expression? So I think that's really interesting kernels of discussion there. But what's the takeaway of this? What does this mean, in your view, for the ability of Clearview AI to continue to function in Canada, continue to function in Alberta? Where do we go from here?
Yeah, and so I guess that kind of turns to the last particular issue, when the court decided that portions to grant this request, that declaring that certain sections of FIPA were unconstitutional and making that amendment to publicly available. They also did restate. Clearview still had to have this reasonable purpose, right? Because the fourth aspect of what Clearview were asking for was that the commissioner was unreasonable in determining that Clearview did not have a reasonable purpose to collect, use, disclose this information. And again, going back to that belt and suspenders approach, right? It's like, you may not need the consent, but you still have this reasonable purpose requirement. And so what was interesting in that was the commissioner was declared to be reasonable in their decision as to what that, determining that Clearview did not have a reasonable purpose to collect, use, and disclose the information when they considered all the factors. And so they upheld that decision of the commissioner with regards to reasonable purpose. And as such, on the balance of everything, they came to the decision that even though they made that change to the regulations, they still said that the commissioner's order was valid and would not be struck down. So Clearview was still subject to the commissioner's orders in the end. And what was interesting is that obviously Clearview, when they were talking about the reasonable purpose test, they again cited Google, similar argument to what the constitutional argument was. They, said, well, Google's purpose is just to index these, images, etc. They're the same as us, but they're allowed to function as they are. And the court really turned to this, well, when we're looking at the purposes, though, Google's purpose is very different to Clearview's purpose. And we are really focusing on Clearview's purpose. And Clearview have not shown us that their purpose is reasonable. Google's is reasonable because, look, they go through index, they provide these functionalities for you to not be subject to indexing if you want. There's procedures that have been set up, and it's for just a very widely different purpose. Clearview, on the other hand, gets these purposes to create this database solely for the use by customers in a commercial context for these very particular purposes, and that is not okay, right? And so the commissioner was right in that decision, and the court had said that's reasonable, and that's why they upheld the order. So it's very interesting to see that they're drawing distinctions between these arguments. They're not just accepting it as a whole and saying, look, because you were successful in arguing, considering Google in the constitutional argument, that we should not side with the commissioner in this particular portion. We're not agreeing to using this argument for this reasonable purpose test. Right now, because they're still subject to the order, Clearview AI are still subject to the restriction on operating in Alberta, even with the court making that decision. So in the near future, they can't continue to operate unless they find ways to comply with that reasonable purpose test still.
Mm-hmm. And we have to remember that going back to the original Office of the Privacy Commissioner of Canada investigations into this, it was a two-part investigation, right? And we're kind of dealing with the first part, which was the legality of Clearview AI's practices in Canada in the first place under federal and provincial law. But then there was also this question of whether it was lawful for police to use this tool that was presented to them. And in that case, this didn't deal with that. But in part because of the failure to comply with privacy law, the commissioners found that RCMP's use of Clearview AI was itself unlawful in that case. And so that's a separate issue here. So it's kind of an issue on the end of the vendor, in terms of the producer of this resource, than an issue on the end of the customer as a public body in this instance under a different law. So lots of interesting stuff here. I think there's a lot of room now between the kind of broadly reasonable purpose granting of Google's activities and the unreasonable nature of Clearview AI for, I think, for other organizations to develop scraping-based technology where the reasonableness question will be now before the courts, right? What is the actual benchmark for what constitutes reasonableness?
Now, we wouldn't be FIPA if we only focused on the privacy side of this. There was also an important investigation report that came out from the commissioner that was, again, started back in 2023 in terms of the commissioner and the province's implementation of FIPA. Mike, you've done a bit of a deep dive on that as well. What are we seeing there? The initial report, from my understanding, is pretty damning.
Yeah, it's it's a really interesting report, and both of these, I would say, the case in particular, I thought was really interesting to dig into. But the report itself, the investigation was pretty in depth, pretty interesting. So, what's this all about? This was a systemic investigation by the Alberta Information and Privacy Commissioner. So, not looking at a particular case of like a refusal of information or anything like that, but an overall kind of whole of government issue involving 27 Government of Alberta public bodies. And the finding is simply that they're non-compliant in processing access to information requests under the FIPA Act, which we have to remember has since been replaced. But the commissioner argues that the findings are substantially applicable to the new legislation as well. So not complying with access requests. And I would summarize this by saying that there was a practice that emerged and became pretty standard operating procedure across a lot of Alberta public bodies that involved access units, so the public body offices that are responding to access requests, seeking to restrict, to narrow, to refuse requests, basically seeking to govern access requests, right? Example would be, you put in a request for the following 3 pieces of information or these kinds of records over this time period with an Alberta public body. body, which is a very standard access request. And they would come back and they would say, you have to pick one of these. You got to pick one issue and we'll file a request on that issue. And then you can file subsequent requests on different issues if you want, but we will not listen to all three of these or look for all three of these things in one request. Or, being pretty heavy handed with just outright refusals or with, insisting on changes in wording. So a lot of these kind of things. And placing limitations on timeframes, requiring applicants to split requests, requiring applicants to structure requests in ways that allowed them to be completed within 30 days. And that's interesting, right? The law builds in a requirement, right? A statutory requirement. So you file an FOI request, the public body is required to get back to you within 30 days. And that's supposed to it's supposed to uphold your rights, right? These are quasi-constitutional rights. And so this is meant to, access delayed is access denied, as we often say. So there is a statutory time limit, which is often exceeded across the board in Canada. But it's there for compliance reasons. And what had been happening in Alberta is they were saying, well, the best way for us to be compliant with the statutory limit is to pressure you to reword your request in a way that it can easily be responded to within this 30-day limit, which means that substantially you're not going to get what you're looking for, right? We're going to ask you to limit things to this kind of bite-sized chunk, and then we can say we're compliant. All of this involved, I think, standard operating procedures that were clearly spread across public bodies, but per the commissioner's findings, were not consistent, right, with the requirements under the FIPA Act in Alberta. We're not, so in other words, they're not basing this on an interpretation of the law or anything that's been upheld by previous decisions. It's kind of an in-house regulation that became standard operating procedure in this case. And it also violated the duty to assist applicants, which is really foundational to transparency laws in Canada, right? This requirement. You can't expect everyone filing an FOI request to have the legal expertise of Sam, for example, on this, to be able to word things in a really nuanced and careful way. You have to expect that people are everyday people, from a variety of walks of life, are looking to exercise their right to know, and they shouldn't have to seek legal counsel to be able to do that effectively. So, for all of these reasons, the commissioner issued this I think Jason and I would agree, pretty damning report that says you have to change your practices, you have to stop doing these things, and you have to be better at facilitating access, which in some ways comes down to having, although they didn't frame it exactly in this way, better information management practices. Right. Don't try and kind of use these ways of essentially gerrymandering requests to work around your flagging information infrastructure.
And that's something we've been hearing a lot of in terms of the information management realm right now, and how that intersects public bodies. I will also note that the commissioner starting this investigation fell on the heels of our commissioner survey in 2023, where we asked all the commissioners across Canada how they would monitor and track the implementation of FIPA in their respective provinces. And so it's interesting to see how some of the commissioners acted on that and sort of put the findings of some of that survey into action in their respective provinces. And there is a whole dynamic in terms of balancing, I think, those dynamics of the duty to assist, where people on the street don't understand bureaucraties, and don't have 15 years in a bureaucracy to understand how to navigate the information systems there, and at the same time need to be helped to narrow their request in an appropriate way, so they're not over requesting information that isn't necessary to fulfill what they're trying to get. So that it's hard to strike that balance when there's such a deficit of trust, I think. And that keeps coming up in a lot of this, as well as we look at these things, talking to other commissioners and folks across the country. Patrick, anything, as you've been looking at all of this, anything else we want to dive into right now?
I think we covered all the major points that we wanted to get to. Looking at Samantha, thank you so much for going the nuances of this. I think that so much of this is for an outsider or like kind of a layman perspective. It's difficult to kind of suss out what's happening unless you read. Of course, a good journalist will go through that and explain it in a way that's understandable. But often this stuff kind of flies by with the noise of all of the major events that are just constantly unfolding. Whether it's coming from the United States, within Canada itself, internationally, and so on. Things are just shaking up so much. So, when these sort of court cases come along or these decisions are made, it's often lost. So I'm glad that we can take the time on this podcast and through this organization to really just sit with the implications of this information and these changes. So, no, I think that was a really great rundown from Samantha, from Mike, and of course, Jason, of course, as well, providing a chronology of events. I would just ask all of you if you have any final notes or thoughts you want to express before we conclude.
Well, I suppose I'll say, just to reiterate, this decision, of course, specifically applies to Clearview AI in Alberta, the FIPA decision, but the implications, the issues, right, around what constitutes publicly available information, about the relevance of privacy law given current technological advancements, the questions of jurisdiction. Even if you were completely unconcerned about facial recognition technology and its privacy implications and surveillance and so on, it's still an important decision because it puts some of these issues on the table in ways that we'll see coming up in future. And Patrick, to your point, we're seeing in some U.S. jurisdictions, extraordinarily expansive adoption of facial recognition technology and other kinds of, scraping-based technologies here. And these things, always will cross borders. That's just the nature of the market for this stuff. So this isn't the final word on this yet, but it's an important step. And I tell my students, if you want to really get a grasp on where privacy is right now in Canada, looking into the Clearview AI investigations is probably one of the best starting points for this. And in addition to going back to, your kind of your classics, your Hunter v. Southam kind of charter interpretations, because it really is kind of like where things are going. So important, I think, for everyone to continue to follow that as well. And the same thing goes for the FOI decision, the investigation by Alberta. These issues around failing to properly assist applicants are not confined to Alberta. And I think it's commendable that the Alberta Commissioner has done this systemic investigation. That takes a lot of time and resources. The findings, I think, are probably applicable to organizations across Canada, and really kind of is a warning that you can't have public bodies interpreting the FOI from the perspective of kind of running defense for the government's information, as opposed to providing a public service for transparency. And it's an important takeaway.
Yeah. All right. Well, thank you all so much for the time. Thank you for that rundown, everybody. Really appreciate it. And I'm sure Samantha will have you on again if you're interested in breaking down some of these decisions again in the future. I'm sure we'll have more subjects to go over with you if you're at all interested in coming on the podcast again, as you've been a really great addition to the analysis that we provide here on the commentary episodes of the podcast. So thank you for coming on.
Yeah, it's always my pleasure.
Yeah. Well, thank you again all for taking the time. Yeah. Until next time.
Thanks, Patrick.
Access and Privacy Online reviews the headlines and delivers deeper commentary on a regular basis. Be sure to subscribe to get the full episodes every week and get notifications when we release show segments and other commentary throughout the week. We look forward to hearing from you soon. Have a good one.